The Supreme Court just redrew the lines, and most Americans didn't even notice it happen. There was no dramatic announcement, no late-night vote in Congress, and no presidential signature on a new law. Yet something fundamental shifted in how authority works across the country. The rules that decide when laws actually take effect, who can stop them, and how far that power reaches, are no longer the same as they were before. For a long time, people assumed that laws only truly change when lawmakers act. Congress debates, presidents sign, agencies enforce, courts review. That is the basic picture most people carry in their heads. But over the past few decades, another layer quietly grew in importance. Enforcement itself became a battleground, and judges increasingly found themselves acting as gatekeepers, deciding not just whether a law was legal, but whether it could be enforced at all. One court order could pause a policy nationwide. A single judge in a single district could block enforcement across all 50 states. It didn't matter if the lawsuit involved only a handful of people. Once an order was issued, the law effectively stopped working everywhere. This practice became common, expected, and deeply controversial. Supporters argued it was necessary. If a law was unconstitutional, why should anyone be forced to follow it while the courts sorted things out? Critics argued the opposite. They said judges were exercising power never granted to them, turning individual courtrooms into national control centers. For years, that argument simmered in the background, unresolved and growing more intense. Now the Supreme Court has stepped in. Instead of focusing on a specific policy, the court focused on structure. Who has the authority to decide what applies to whom and how far that authority goes? The justices made clear that courts exist to resolve disputes between parties, not to supervise national governance. When judges issue orders that apply to people who were never part of the case, the court said, they step beyond judging and into policymaking. That distinction is not abstract. It cuts directly into how power flows in the American system. The court's reasoning rested on a simple principle. Judges are unelected. Their legitimacy comes from applying the law to specific cases, not from managing the country. Nationwide enforcement decisions belong to the political branches, which are accountable to voters. If courts expand their reach too far, that balance breaks down. This is where the lines were redrawn. The Supreme Court did not ban all broad court orders. It did not say judges are powerless. What it did say is that remedies must match the case. Relief should apply to the people actually before the court, not automatically to everyone else. Anything broader requires clear justification and extreme caution. That single shift changes everything. Federal agencies immediately took notice. Programs that had been frozen nationwide because of one court ruling suddenly required reevaluation. Some policies that had been stuck in legal limbo may now move forward in parts of the country. Others may advance unevenly, shaped by where lawsuits are filed and how narrowly judges write their orders. State governments reacted as well. Attorneys general who once relied on sweeping injunctions must now rethink their strategies. Instead of one lawsuit creating national impact, they may need multiple cases across multiple courts. States defending their own laws may feel newly empowered to enforce them beyond limited judicial boundaries. Businesses are watching closely. For years, nationwide pauses created predictability. A rule was either on or off. Now compliance may depend on geography. A regulation might apply in one state but not another. Companies operating nationwide face higher costs, more legal uncertainty, and greater risk of missteps. For ordinary Americans, the change is quieter but just as real. Laws affecting healthcare, employment, immigration, education, and voting may now feel different depending on where someone lives. Two people under the same federal statute could experience entirely different outcomes based solely on location. Supporters see this as federalism reasserting itself. Critics see it as unequal treatment under a single national constitution. The Supreme Court anticipated those concerns. The majority emphasized that courts are not meant to guarantee uniform outcomes. They are meant to apply the law correctly within their limited role. If uniformity is lacking, the responsibility lies with lawmakers, not judges. Clearer statutes, better legislation, and political accountability are the proper solutions. This ruling also changes incentives throughout government. Agencies may act with more confidence, knowing one unfavorable ruling is less likely to shut down an entire program nationwide. Lawmakers may feel greater pressure to act decisively rather than relying on courts to resolve disputes indirectly. Advocacy groups may need to invest more time and resources into sustained campaigns rather than single lawsuits. Lower courts now face a period of adjustment. Judges must be far more careful about the scope of their orders. Remedies must be tightly tailored. Overreach risks swift correction from higher courts. Some judges will adapt smoothly, others may test boundaries. Conflicting rulings are almost inevitable, increasing legal complexity and uncertainty. Politically, accountability shifts. When courts step back, elections matter more. Policy outcomes become more directly tied to who holds power in Congress and the White House. That was central to the court's reasoning. Democratic processes, not judicial shortcuts, are meant to resolve national disagreements. Critics warn that history shows moments when courts were essential to protecting rights that lawmakers refused to defend. They fear narrowing judicial power could leave vulnerable groups exposed. Supporters counter that unchecked judicial authority carries its own dangers. The ruling does not resolve that debate, it resets it. What cannot be denied is that the Supreme Court has changed the terrain. Without passing a law, without striking one down, and without public spectacle, it redrew the boundaries of enforcement authority. The consequences will not appear overnight, but they will shape how laws are applied for years to come. The lines have moved, and everything built on them will move next. Now, the real question is not what the Supreme Court did, but what happens next. Because when the court redraws the lines, every institution standing on those lines has to adjust its footing. The effects of this decision will not arrive all at once. They will unfold quietly, case by case, state by state, policy by policy. One of the biggest changes is how legal challenges will be fought. For years, a single lawsuit could reshape national policy overnight. That era is fading. Challenges will now be more fragmented, more regional, and far more complex. Instead of one decisive courtroom battle, the system is moving toward dozens of parallel fights happening at the same time. That favors some actors more than others. Well-funded organizations and state governments can afford long legal campaigns across multiple jurisdictions. Smaller groups may struggle to keep up. The result is not just a legal shift, but a strategic one. Power increasingly flows toward those with the resources to sustain pressure over time. Federal agencies are also adapting behind the scenes. Enforcement decisions now carry more weight because fewer nationwide judicial breaks exist. Agencies must decide where to act first, how aggressively to proceed, and how much legal risk they are willing to accept. Some will move faster, others will proceed cautiously, knowing that uneven enforcement invites political backlash. States may become even more important players. With fewer blanket rules imposed from above, state-level enforcement differences will grow more visible. Some states will push boundaries, others will resist. This deepens the role of geography and how federal law is experienced, reinforcing the idea that where you live increasingly shapes how the law touches your life. For citizens, this can feel unsettling. The promise of uniform national rules has long been part of the American legal identity. This ruling does not erase that ideal, but it complicates it. Rights still exist, but their protection may now depend more heavily on local courts, local politics, and local enforcement choices. Supporters argue that this is how the system was designed to work. The Constitution divides power deliberately. Courts interpret, legislatures legislate, executives enforce. When one branch expands too far, correction is necessary. From this view, the Supreme Court did not weaken the system. It restored balance. Critics remain uneasy. They point out that balance on paper does not always mean fairness in practice. History includes moments when courts were the only institutions willing to stop harmful policies. Limiting judicial reach, they argue, risks repeating old mistakes under a different framework. The Supreme Court did not deny that history. Instead, it made a choice. It decided that long-term legitimacy depends more on constitutional structure than short-term outcomes. That is a philosophy with consequences, both intended and unintended. Another shift lies in political responsibility. When courts no longer serve as the primary stopgap, elected officials face more direct pressure. Voters can no longer assume judges will step in to fix unpopular or controversial policies. The burden moves back to legislatures and executives, where accountability is clearer but conflict is sharper. This may intensify politics rather than calm it. More issues will be fought through elections instead of injunctions. More disputes will play out in public debate instead of legal filings. That can be messy, slow, and divisive, but it is also more transparent. Over time, the legal system will adapt. New precedents will form. Lower courts will refine their approach. Lawyers will develop new strategies. What feels unstable now may eventually settle into a new normal. But one thing is already clear. The Supreme Court did not simply decide a case. It changed the rules of engagement. It narrowed the space where judges can act broadly and expanded the space where political power must take responsibility. The lines have been redrawn not in ink, but in authority. And once authority shifts, everything connected to it shifts too. That is why this decision matters, not because of what it stopped, but because of what it set in motion.